I wanted to discuss the Court of Appeal decision that was released recently that decides the question of budget bills. You know, the parties waited almost 4 years for the Third District Court of Appeal in Howard Jarvis Taxpayers versus Shirley Weber, Josh Newman, Real Parties in Interest. And the third DCA ruled 3-0. So Howard Jarvis Taxpayers Association had brought two petitions for a writ of mandate in an effort to challenge the constitutionality of legislative amendments that were contained in two different bills that changed the procedures governing the recall of state officers. Now, the legislature had changed the law regarding several of these proceedings used in the recall of a state officer, including legislators, when it adopted Senate Bill 96 in June 2017. Howard Jarvis Taxpayers Association filed its petition arguing that SB 96 was unconstitutional because the bill violated the single subject rule in Section 9 of the California Constitution, Article 4. And so the court granted the writ and stayed enforcement of SB 86. Then the legislature adopted similar but modified changes to the recall process in Senate Bill 117, which was a budget-related bill. So HJTA filed a writ challenging that bill on several grounds, including that the bill was not a valid budget-related bill that could be passed by a majority vote and take effect immediately under Prop 25 that the people adopted in 2010. So the Third District Court of Appeal specifically requested the two parties to this litigation to address two questions. Does the legislature of the state of California have the authority to, one, amend the budget bill by a majority vote, and two, adopt quote unquote other bills providing for appropriations related to the budget bill to become effective immediately by a mere majority vote? And the appellate court in this case ruled 3-0 against the writ petitions. They published the decision, and it provides important guidance on the interpretation of Proposition 25. Again, Prop 25 was adopted by the voters in November 2010 and known best as changing California from one of the three states with a 2/3 majority vote requirement for passage of the budget to a simple majority. And Prop 25 specifically amended Article 4, Section 12 of our state constitution. So California's constitution in Section 12E1 now provides, after Prop 25, that the legislature may pass both the budget bill and other bills providing for appropriation related to the budget bill by a majority vote, and those measures take effect immediately upon signature by the governor and, of course, chaptering by the Secretary of State. In addition, Section 12E2 defines other bills providing for appropriations related to the budget bill to consist only of bills identified as related to the budget in the budget bill that's passed by the legislature. So in August 2017, the legislature enacted and the governor signed SB 113 and SB 117. Now, SB 113 was what we call a budget bill junior because it amended the main budget bill that had been adopted in June of 2017. And then SB 113 contained a list of bills that were designated as related to the budget bill, and that those would be effective upon being chaptered. SB 113 contained an appropriation for the costs of a state Senate recall that was going to happen in the state of California in Orange County. SB 117 was one of the bills designated in SB 113 as being related to the budget bill. And in fact, SB 113 contained a legislative finding and declaration that numerous bills, including Senate Bill number 117 or other bills providing for appropriations related to the budget bill within the meaning of subdivision E of section 12 of Article 4 of the California Constitution. So SB 117 repealed the recall provisions of SB 96 and then enacted similar provisions with a few modifications. Specifically, section 17 of SB 117 provided the language that SB 117 is in fact a bill providing for appropriations related to the budget bill within the meaning of subdivision E of section 12 of Article 4 of the California Constitution, and has been identified as related to the budget in the budget bill and shall take effect immediately. So both SB 113 as well as SB 117 were adopted by a majority vote of both the Senate and Assembly and then signed into law by the governor. Now, the Third District Court of Appeal, in analyzing the Howard Jarvis Taxpayers Association legal challenge, said, "We presume that the challenge statute is constitutional and uphold it unless its unconstitutionality clearly, positively, and unmistakably appears." The Court of Appeal also said, "We do not look to the Constitution to determine whether the legislature is authorized to do an act, but instead consider only whether it is prohibited." So the first claim made by HJTA was that SB 117 violated a right to a speedy recall election, and that the additional procedural hurdles that SB 117 enacted in the recall process violated the voters' due process rights. The Court of Appeal rejected this claim because the petitioners failed to cite any language in the California Constitution to support the assertion of a right to a speedy and immediate recall election. Also, they said the legislature has the power to adopt rules related to the recall procedure, and they exercised that power in SB 117. The second claim by Howard Jarvis Taxpayers Association was that the issues before the court were identical to and already resolved by the appellate court in an unpublished opinion from 2013. And the court here disagreed, saying that the prior case dealt with so-called spot bills that had been identified in the budget bill as being related to the budget, even though they didn't have any substantive content in those spot bills. The appellate court in the 2013 case ruled that Section 12 of Article 4 does not allow the legislature to name empty spot bills in the budget bill, and only after the budget bill is passed to fill those placeholders with content as urgency legislation. Specifically, the court ruled in the 2013 case that a spot bill referenced in the budget bill is neither identified nor is it an actual bill. Now, in this case, on the other hand, the Third District Court of Appeals said that Senate Bill 117 is not a spot bill. Instead, it's a new budget bill, again, which we commonly refer to in the process as a budget bill junior. And then the third claim that HJTA made was that only the budget bill can be passed by majority vote, and all the other budget-related bills must be passed by a 2/3 vote as they make appropriations. And the Third District Court of Appeal also rejected this argument and called it a cramped, restrictive reading of Proposition 25. Now, Howard Jarvis Taxpayers Association argued that Section 12 of Article 4 refers to the budget bill, and that its majority vote provision only applies to the budget bill. The appellate court said that the phrase "the budget bill" must be considered in context, and that the California Supreme Court has already determined that budget bills junior are part of a budget bill. According to the state's high court, they said, there is no substantive difference between a governor's reduction of an item of appropriation in the original 2009 Budget Act and a governor's reduction of that same item in a subsequent amendment to the 2009 Budget Act. In other words, the Supreme Court said both the original budget bill and the later reductions were an extensive and multi-tiered budget bill. Moreover, in the city of Cerritos versus state of California, a 2015 Court of Appeal decision, the Third District Court of Appeal said that the phrase "other bills providing for appropriations related to the budget bill" include trailer bills if those trailer bills contain appropriations and are identified as being related to the budget in the budget bill itself. So finally, in its written decision in this case, the Third District Court of Appeal reasoned that SB 117 contained an appropriation, and the Budget Bill Junior, SB 113, identified SB 117 as a trailer bill providing for appropriations related to the budget bill. And therefore, based upon the plain language of Section 12E of Article 4 of our state constitution, SB 117 was in fact a bill that provides for appropriations related to the budget bill and therefore became effective immediately with just a majority vote.